Welcome to the third in the series of mock civil mediation programs. Today's role play will last about 30 to 35 minutes. At the end of the role play, please ask your questions by raising your hand. I do not follow chat during the role play because I need to pay full attention to what the players are doing. Because we have so many players today, I'm going to ask each of them to briefly introduce themselves and then go directly into the role play. So Brad, I'm going to start with you. You introduce yourself, go around and ask the others, and then go directly into the role play.
Okay, I'm Brad Ferenz. I am a retired judge. I've been doing mediation for the last 6 years, and I'm hopeful that this webinar we're doing will be helpful to you. In no particular order, basically how they show up on my screen. Jack, why don't you start? And then once you introduce yourself, ask the next person to introduce themselves.
Good afternoon. My name is Jack Anagnostis. I'm a retired attorney, worked for IRS for about 32 years. And during that time, I began mediation on a part-time basis since about the 1980s, and then full-time from about 2010 till today. And I'm very pleased to be joined by colleagues who have much more experience than I do and can add a lot to this role play. Thank you. Denise, would you like to introduce yourself?
Sure, thanks, Jack. Good morning, everyone. Good afternoon. I'm Denise Winogle. I am a solo family law attorney in Morristown, New Jersey. I practice collaborative divorce and mediation, and I've been doing that for a little over 10 years now. And I'm very happy to be here today and playing one of the parts. Thank you.
And Lucille, why don't you introduce yourself?
Good afternoon. I'm Lucille Alfano. I'm a retired union president, 20 years union president of a city school district in New Jersey. I am an accredited professional mediator, and I'm a labor arbitrator. I am also the vice president of the New Jersey chapter of Labor and Relations Employment Association. So welcome, everybody. And Michelle, you are my attorney. Introduce yourself.
Good afternoon, everybody. Thank you. My name is Michelle Cresty. I'm a partner in the firm Macy & Cresty. We're primarily a litigation firm. I have been arbitrating and or mediating since approximately 1998, where I got my start in New Jersey Superior Court arbitration. So I've been doing that. That's been part of my practice ever since. So.
Well, I'd like to start our mediation right now, if it's okay, folks. I would like to go over, if you would, where we are and where I'd like to get. First of all, I want you to remember, this is our second mediation. The first mediation I thought went particularly well, and I appreciate everybody working really hard to come to, if nothing else, close to resolution and agreeing on what the basic facts are. But before we go any further than this, I want to make sure everybody understands that we've received a call from the court. And you folks are going to go to trial in a couple of weeks if we don't get this resolved. And let me tell you what that means so you understand clearly. I know I said it to you before, but let me remind you, if we can't resolve it today, a judge is going to decide it. And while I have a great deal of respect for the judiciary, they're going to tell you what to do. And my understanding from both of you after speaking to you is neither one of you like to be told what to do. So the only way to avoid that is to make your own mind up of what is a fair and just resolution. Now, my understanding is that you two, Tina and Jane, you have been working together all your adult lives. You've invested in different properties, and up until recently, you had a pretty darn good working relationship. A couple years ago, as I understand it, both of you got together and made a substantial investment in a shore hotel, something in the neighborhood of $3 million, and you did great for that for, 10 or 15 years. One of you decided, or both of you decided, it's time to leave and look for another property. And in fact, John left with Jane and took out the initial investment they had made in that first hotel, $750,000, and bought a great place somewhere else on the Jersey Shore, and that place is doing terrific. And I think that's great. The idea, as I understand it, was that now that we had one couple out of the hotel, you're going to sell the first hotel. And the other couple, Tina and Tom, were going to make an investment of $750,000 which is what I understood you guys agreed to, and buy into the other hotel. Well, unfortunately, that hotel, the first hotel, did not sell for what you wanted it to sell for. In fact, it sold for substantially less, $500,000 less. And now we have a discussion and argument because, as I've been told, the people that have the hotel now, Jane and John, really are kind of hesitant to permit the sister to buy into the hotel for the same price of $750,000 because they're telling us that the hotel now is tripled in value. And I think that the $750,000 that they spent, quite frankly, was well spent, but they worked really, really hard to bring the value of that hotel up. And they really ought to have a higher payment, if you will, to buy into the hotel. They also feel, and my understanding is that based upon all the mortgages and the debts, there's about $1.75 million left to be distributed. And my understanding is initially that was to be split 50-50. My understanding is that Tina and Tom took out their $750,000 investment that they both couples put into the first hotel. And that remaining portion, that $1.75 million, is now also up for discussion. Because as I understand it, we have a discussion and disagreement as to how that is going to be split. And that's what brings us here today. Basically, two issues. The first, at what price and if the Tina and Tom can buy into the hotel that John had bought with his wife, Jane. And second, how will the hotel proceeds from the first hotel, the $1.75 million, be distributed? 50-50 or some other way? Now, what I'd like to do before we break into caucus is ask each of the lawyers to tell me what they think ought to resolve, how they feel this thing should be moving, because I'm sure over the last week, you've been speaking to your clients and trying to get somewhere to a reasonable resolution. Understanding again, if we can't do it today, we're done. You go to court and resolve it that way. And if you resolve it here, I'll tell you flat out, three things occur. A, you save an incredible amount of money because you do not have to spend the money on litigation. B, you become certain of the result because you make the result. You decide what's going to happen. No court tells you what's going to do. Okay? And no less importantly, you save time because it'll be done today. I would also tell you that if you can resolve it yourselves, it goes a long way to you two getting along again, to the two couples being able to deal with another again. Because when a court makes a decision and it's not your decision, there's always some degree of resentment. So I ask you each, listen carefully, very carefully to what the other person is saying and understand that mediation, you don't get everything, it's a compromise. So please listen carefully. Jack, since you're the moving party here in the plaintiff, what do you think we can do to resolve this matter?
Well, first of all, I'd like to make sure I understand the sisters' perspectives. There's a difference in the value of the properties. Hotel 1 selling for less than what they thought it would sell for, and Hotel 2 apparently increasing in value, maybe by threefold. And if I understand correctly, the sisters seem to be focusing on management as the reason for the difference. Okay. Now, what I'd like to do, I mean, is that correct, first of all? Jane, are you saying that your sister Tina did not manage the first hotel properly and that's why it didn't sell for as much as you thought?
If I may,
Yes, I'm sorry. I should have addressed your attorney first.
Mm-hmm.
Thank you.
Can you help us out with that so we can define the issues as clearly as possible?
Yes, please. Can you restate the question?
Right. I want to make sure I understand that from your perspective, the way the property was managed, both properties, is the reason for the difference in the values.
Yes, that is correct. Our position is very simple. The facts speak for themselves. We're looking at pinpoints in time. The pinpoint in time when my clients sold the property of the hotel number 1, the property had a value. Now we look at it today, it's that value minus $500,000. So the only people that were in it at that point was your client. Similarly, my clients bought the second property at a pinpoint in time and it has trebled in damages. And again, the only folks that were there were my clients.
Okay. Now, if I can, I want to pick up.
Mr.
Well,
My
I
name
don't
is-
know
Mr. Ferris
exactly.
would like to speak with us.
Well, I don't know exactly where we're going to end up. Please understand that in order to resolve this stuff, both parties are going to have to compromise. And what I'd like to do, if it's okay, is speak to each party individually to find out what it is they think will make this work. So let me take Jack first and his client, Tina, and see exactly where they are and if I can resolve this. Okay?
Okay, we'll go
If
wait in
I
the
can-
waiting room.
Yeah,
You're
well,
breaking
here's
into a
where I
caucus.
was going to
Ask
go.
Michelle and Denise Mealy to turn off the sound. So, Jack, what can we do to resolve this?
All right. Well, what I was going to do is then turn to my client and ask her, putting aside the issue of management, if you put that aside and you wanted to talk to your twin sister as a sister, what would you say to her? And what effect would that have on how you would want to resolve this situation?
Well, I'll tell you, I really resent the fact that her attorney keeps blaming me for mismanagement when I did everything in the 2 years to try to sell that hotel and it wouldn't sell. So we can't say it was a value. It was valued higher 2 years ago. It's a value when you sell it. So I really, really resent that and it bothers me. But, you know, one of the things I'm concerned about is, you know, my sister and I have always worked really, really well together. And, you know, this was a deal we had made like every other deal. And I'm just really confused as to why she's trying to screw me like she is. And I don't know. I need to find out whether or not, and this really matters to me the most, I need to know whether or not we can work together. And will a judge ever be able to say to us, to tell them that they have to work with me, me and my husband?
I can tell you, Tina, a judge is not going to tell you that you have to stay in a relationship, business relationship. I can also tell you that if you litigate this, you might get everything you want. On the other hand, you might really not get everything you want and do it very poorly. So you have to figure out what it is that you can live with that makes you comfortable. And as I understand it, and you can correct me if I'm wrong, that will enable you to continue in the relationship in business with your sister. Is that what you'd like to do? Continue in
Well,
business?
yeah, that's what I would like to do, but I'm not going to want to do it if she doesn't want me to work with her anymore. And so I think that that's like the critical question here about where I'm going to go and what I'm going to do. Jack and I have had many conversations about compromise and, you know, trying to reach a win-win. I don't know how that's going to happen unless she decides that she can work with me. If she can work with me, you know, I love her and I really do want to work with her again, but you know, this is really causing a big trouble for us.
Denise, let me do this. Let me ask them. I'm going to talk to them, but let me break it down to issues. As I remember, you were supposed to be able to buy into the business, the second hotel, for the same price that they bought in, $750.
Absolutely, yes.
Why don't we deal with it as two different issues? Because if she wants to work with you, then let's get a price that you can buy in at. And if she doesn't want to work with you, well, then it becomes dollars and cents, and we can move on to just a resolution that deals with no personality, no working together. And unfortunately, it'll probably be really tough on the family because you guys have been close all your lives. Okay?
Well, the ball's in her court. The ball's in her court.
Jack, does that make sense to you?
Yes, it does. So you're going to be speaking with them, and what Tina wants to know is whether her twin sister is willing to work with her. Now, what would be the indication that she does? What are you looking for, Tina?
Well, why don't you guys talk about that while I talk to the other side and see if they're even willing. They may just want to have dollars and cents. I get the impression from Tina that she loves her sister and would really like to, well, kind of heal the relationship as best she can to make the business work. Okay, so let me speak to Michelle and John and see if we can get this matter resolved, or John and Jane. Okay.
Okay, thank you.
All right. At this point, I would like counsel to come on along with her client. Here they come. Okay, counsel, let me tell you where we are, because what I'm trying to do is get this matter resolved, because as you know, if we don't get it resolved, you're going to go to a courtroom and nobody knows what a court's going to do, what a jury's going to do. And your client could do well, she could do poorly, but if we resolve it, she'll get exactly what she wants because she'll be agreeing to it. So let me ask you, we broke it down into two different areas. The first area, which I think is very important, is can the sister buy into the new hotel? And if so, at what price? That's the first question. I know your client bought in 2 years ago for $750,000. I understand there was a deal to buy in for $750,000. So let me ask you, is your client willing to? Does she want to do that? What's her position? Well, maybe I should speak to her directly. What would you prefer, counsel?
Tina, do you feel comfortable talking, or would you like me to express the opinions that you've shared with me in our caucus?
Joan.
What,
Say,
what did you say?
Jane.
Jane, I'm sorry.
Tina's my sister.
Sister.
I know you. I know I love her, and I know you want us to work together. But I'm Jane.
Sorry about that, Jane.
Jane, I guess the first question we have to answer is really two things. A, can you work together and do you want to work together? I can tell you that I've been authorized to say your sister would like to work with you. She loves you. She cares about you. She wants to put this behind us, behind the two of you. You've worked together really well all your lives. This is a bump in the road, and she'd like to buy in and manage a new hotel with you. So my question to you is, can she do that? And if are you comfortable with that? And the second question would be, what would you be looking for? Would you accept the $750,000, the same price, the same buy-in that you paid?
My sister is my twin. We have been together since birth. We have worked together. I want to work with my sister.
Excellent.
But don't forget, we have husbands. And I don't want to tell you, think about why when she, with her husband, without me there, took on Hotel One, what happened to it?
Went downhill.
Okay? Right.
It could have just work it. But,
whatever. The money is the money. The money is the money. We're talking about money now because we have to talk about money.
Let me try. There's two things. A is the money, and B, do you want to work together? I hear you saying you want to work together. So do I have authorization to you to go back and say to them, yes, you want a partnership again? It's a matter of cost. What will it cost them to buy in? Is that what I hear? Counsel, Jane?
As long as I know that my sister, Michelle, help me out here because I love my sister. I love my sister.
All right, Jane,
but we got to watch out for anything behind us, okay? And the money is the money.
Jane, are we, Judge Ferris has been helping us a lot here, and he broke it down, understandably, in two parts, right? First, there's the relationship with your sister, then there's the money. So this business deal is somewhat more complicated because there's a familial sister relationship. And of course, if you want us to preserve that, is that one of your goals? I want to get that straight. Is that one of your goals here today, to preserve your relationship with your sister?
Yes.
Okay. And
I have to make that my goal.
Okay. So not only as a sister relationship, but now that's the second part of that. Do you want to maintain a business relationship with your sister?
I would like very much to maintain a business relationship with my sister, but in no way are we going to do that where it's not equal and correct. Because this is not working out money-wise.
Gotcha. So can I? I'm sorry, Judge. Can I just ask one more question before I forget? Am I hearing in this, Jane, a little bit that the husbands have something to do with it, and I'm just dragging in a little bit of like personal family, just living on this earth all these years. You kind of know how things go. Are you saying that the husbands are making it more difficult?
Well, when my sister and I ran Hotel One, we were getting X amount of money.
Okay.
I leave, and now it's she and her husband. So, come on.
Okay. So maybe any deal we strike, Judge, do you think, based upon your conversations with the other room, because of course we don't know what was said over there, do you think that we can somehow bake something in the agreement that Jane and Tina are quote unquote in charge, which I understand is how things went in the past, but maybe somehow more formalize that agreement?
Well, let me ask this. There is, as you guys know, a significant amount of money, the $1.75 million that has to be divided. Could I ask you to consider two things? A, what you want is a partnership of Jane and Tina. I don't think that, that's a problem. I think that's perfectly fine. And you'll be able to manage the place, the two women, the way it was managed before. And I'd like to ask you to consider the same buy-in for them. Understanding you've got $1.75 million to distribute that hasn't been distributed from the sale of the first hotel. So you can work on equalizing everything from that money. But the first,
right, because they've already lost 500,000.
Right. So that's something I'd like to start with by saying, if it's okay, let's separate the issues. If we can come to agreement on the buy-in, then let's move on to the distribution. What do we do with the 1.75 million? Is it split 50-50? I know that's what your sister would like, but I know you don't want that. So maybe if we can sweeten the pie, if you will, and permit her to buy in at the same price that you bought the hotel, the $750,000, which I understood was kind of the agreement, although there's nothing in writing. You guys have dealt without writing forever. And I might say, Michelle, you might want to make sure that this agreement is in writing so that everybody understands the two young ladies that are taking charge. Okay.
Yeah.
They're managing this. So do you think I can do that? Do I have your authorization to speak to your sister and her lawyer about that kind of buy-in, the $750,000, providing it's only you and your sister who do the management?
Do you understand all those?
Well, no, the only thing I understand is whether or not our mediator is going to look to have my sister and I be the managers of the hotel I am already there with my husband.
Yep, correct.
And we've had it go sky high because of our management. I know my sister would equally do that kind of work, okay? But they've already lost. We have less money to split because of them.
Okay,
all right.
But we can't. I understand, but Jane, here's the thing. At some point, one of us is going to have to give a little. So we made a lot of good work, right? We made a lot of good progress here. You've agreed that you wish, at least in theory, to go back and have a relationship with your sister, and as a corollary to that, you've also agreed that you wish to have a business relationship with your sister. I think you enjoy that relationship, and I think you miss it, and you want to go forward with that. I've learned that as I've been talking with you over the lifetime of this case. So we're correct there, right?
Yes.
So now let's figure out the money, right? So now here we are with the money, and there's two money issues. The first money issue is, how do we split the proceeds from Hotel 1? That's money issue 1. Now there's also
The buy-in,
Hotel 2.
the buy-in to Hotel
The
2.
buy-in to Hotel 2.
That
So,
we skyrocketed. Right.
Go ahead. What'd you
That
say?
we skyrocketed
Right.
on our work.
So your
Right.
good hard work. Which you think that your sister was also capable of. Go ahead, Judge.
Before we continue, understand that you guys are due in court in about 10 minutes. So let's decide whether or not you can accept a buy-in for the $750,000. So I can go back and find out if they will accept that. And then let's talk about dividing the profit. And maybe we can work on that as a unequal split so the matter can be resolved.
What do you think?
Well, only if it's something that's acceptable. If there's enough money if there's enough money from the 1.75 that's existing, that's not going to be split half. I'm telling you.
Let me ask
All right,
And
so, Jane, here's the thing. While we're talking,
Let me
Right.
speak to the other folks about whether or not the first part of the deal is acceptable. And that is
okay.
$750,000 buy-in for the equal share, as long as Hotel 2 is managed by the two ladies, Jane, and Tina. And then explain to them there's going to be some kind of apportionment of the remaining profit, the 1.75 million. If they say yes, then I'll bring everyone together. We'll put that portion which we agreed on the record, and we'll begin to discuss how to divide that 1.75 million.
the only thing, Judge, we're going with the good, with the confident thought that we're going to resolve all three issues, but can we go back there with the understanding that if we cannot resolve the $1.75 million to the satisfaction of Jane, then the whole thing is off?
I think that it's not over till everybody signs a memorandum of understanding, and I think that's a very good and clear point that I will pass on.
Okay, perfect. Jane, I think that's good.
So
I think we're good so far.
Michelle, I'm going to ask you two guys to talk together to find out how you'd like to divide that, 1.75 million. But I want you to understand that, and I don't want to speak for anybody, but it's a lot of money, and try to be as fair as you can in the equitable split. Understanding that a lot of times it's just location. Not that you didn't work really, really hard, but a court looking at it could just say it's location, not hard work, because I'm sure your sister's going to tell me that she worked really hard in the other hotel. It just didn't sell for what you'd hoped it'd sell for.
Judge, so maybe you can get, maybe we don't want to bid against ourselves. Maybe they can make an offer to us of what they think a reasonable split would be, and then we'll kind of jumpstart it, okay?
I will do that. That sounds like a terrific idea.
Perfect.
Let me have, if I could, if you'd go into caucus, so that means you would go silent. And if I could have Jack and his client, Tina. There you are. So let me tell you where we are. Your sister really, really enjoys working with you. She talks about it as if it was something that made her life really, really pleasant, really fun. And you guys were able to make a living for all your lives, basically. You're in your early 60s, and I guess, 40 years? You survived, both of you, both couples, on the income from this different businesses. She'd like to go back. And what she said is, look, I bought this place for $750,000. That was my buy-in. So in fairness, I'll let you buy in for that same amount of money. However, because it's tripled in value, I really think I should have a little more of that 1.75 million, because that's the profit from Hotel 2 or Hotel 1, I'm sorry, the first thing you bought. And the reality is, for better or for worse, it just didn't sell for what you wanted. It was unfortunately held for 2 years. And during those 2 years, it kind of unfortunately depreciated while in your care. And the other place tripled in value, tripled. And you'd be buying in for the same thing they bought in for. So you're buying in for substantially less, maybe in theory, a third of what the value is of that $750,000. So if that's acceptable, what they asked me to do is ask you, and Jack, I'll put this in your hands, what would be an acceptable division of that $1.75 million?
Wait, can I go back though? I just want you to know that we all estimated Hotel 1 to be at $3 million. And it took me 2 years to sell it, and it wasn't sold at $3 million, and it wasn't my fault, and it wasn't my husband's fault. It wasn't mismanagement. However, they're saying that this, the new hotel, and I'm not saying I'm not going to do this, but I just want you to know that the new hotel, they're saying, oh, it tripled in value. What proof? I beg to differ. How do they know? I'm willing. I want to work with my sister. I am thrilled that my sister said that she will work with me again. So I'm willing to do it.
We would like an offer. Some disparity in the income. We're in the division of the 1.75 million.
So that's a separate thing. But what you're saying, let me clear my mind and make it clear that I can take the 750 we already have, that my husband already have, put that into the Hotel 2, and then that will be shared equally. Like we will move forward like we always did with Hotel 1 when we were together.
One difference. Mm-hmm. It's going to be in writing. And you and your twin sister will manage. Okay.
Okay. I'm happy with that. I don't know how my husband's going to be, but
I don't, you guys are the brains. I don't need to be disrespectful, but you guys have been the brains in the outfit all your lives, and they should resolve themselves to this. You guys do a great job. You guys should do it. That's a condition of the resolution on that. Now understand that it's not resolved till it's all resolved. So that's one piece. The second piece is, what can you offer by way of giving them a couple extra dollars of that 1.75 million.
Right. Here's what I'd like you to think about, Tina. Let's say that your sister is correct, that the value of Hotel 2 has tripled. So you're really buying into a hotel that's worth more than the one you sold, and you're getting in for $750,000, the same amount she paid. So what would you think about somehow dividing the 1.75 million to give her a little bit more because the Hotel 2 is worth more than what she bought it for, and you're buying into greater equity.
You know, it's
So is there something you might be willing to give on the 1.75 million to recognize that Hotel 2 was worth more, and when you and your sister eventually sell it, you're going to get the benefit of that increased value?
now understand that I'm not your lawyer. You have to listen to your lawyer, not me, but that makes perfect sense to me. And maybe you ought to think about the fact that it sold for $500,000 less. So make her happy by splitting it so that she gets that $250,000 she anticipated. So you'll get 750, she gets $1 million. And if you want to make a different offer, I can do that. But that would equalize it for her, and it would still give you pretty substantial sum of money in a hotel buy-in that's, well, what your lawyer says is true, a very, very low price. And more importantly, you make the decision. Some judge isn't doing it, and you get to work with your sister again.
Well, I agree. I love what you said. I love what you said, because I really miss my sister, and this has been such a horrible experience for our family. And putting something in writing is fine. I agree to that. Giving her a little bit more. I just, you know what, what's really bothering me is that she's accusing me of mismanaging the property. If she would just stop accusing me, I would be like, okay, you know, just to settle it. I understand what Jack said, because yes, the money is the money, and I would be making, you know, I'd be giving a little to get a lot.
Let me interrupt you for 1 second. I don't think she has any grudge. I think that the reality is she wants you to buy in at 1/3 its current value. That 750 that she put in, it's now probably 1.5 million because the hotel has tripled in value. That's what the real estate folks say. So I think that she's giving you a heck of a deal if you can get her to do that. And I don't think it's mismanagement. I think what happens, and she knows it, is, you know, it's location. You know, real estate people, location. And what's the third really important thing about real estate? Location.
Let me make one other point to
Yeah.
to Tina. If your sister thought you were not capable of managing,
Good point.
why would she agree now to have you go in with her and manage the new hotel?
There you go.
Exactly. I know. I guess I just have to get over what all of the harsh things that have been said throughout this whole time, you know,
Right.
and I guess I need to deal with that, but I'll be very happy if you guys can help me settle this with my sister. And I'm okay with this.
What I'd like to do is bring everybody back together. I'd like to have the lawyers, Jack and Michelle, talk with you there so they can listen. You can listen, and they can talk about what a reasonable resolution is. And if you can come to that reasonable resolution, I'll write it up. You'll sign it. It'll be combined today, and it'll be done. You guys will get this weight off your shoulders. You'll walk out of here feeling so much better that the matter is resolved. So let me have Jack and Jane and all right, Michelle and Jack and the other two folks, the two young ladies here, that I think that both these women loved working together and want to go into business together. My understanding is that if they're permitted, you know, Tina's permitted to make a $750,000 buy-in, that she will in fact do that for an equal share, and she is quite comfortable, Jane, very comfortable with a written agreement that says it's the two of you, nobody else. You two decide. You're the brains of the outfit. You two decide, no one else. So the real issue is the division, I think, of the $1.75 million. And because the new hotel has just skyrocketed in value, I think that Teenage wanted to give you a little more of that 1.75 million. And I would ask Jack to talk about what a fair trade-off as he sees it, and Michelle to talk to Jack as the lawyers talk, and I'll listen, and maybe you guys can come to an agreement, and that would resolve the whole matter. Jack, what do you think would be a fair split, if you will, on the 1.75 million?
Okay, well, just like to let you know that Tina recognizes that for the 750,000, she's buying into Hotel 2, which has increased in value. And she's willing to recognize that by allowing Jane a greater portion of the 1.75 million. As a matter of fact, She's willing to give Jane 1 million, and Tina will keep the 750,000.
So basically, she's going to give up $750,000, which is really half of the $500,000 that they thought the hotel was worth. So it would make her whole. Is that basically the position you're taking, Jack?
Yes, yes, it is.
Michelle, it sounds like a pretty good offer. I don't know what else, and if you want to speak to your client privately or you want me to take part in it with you, your client becomes whole. She gets the extra money that she thought she should get based upon the valuation of the first hotel. And she's got her partner back and an agreement that it's only the twins, not really two twins, it gets the twins, the young ladies that will be managing the hotel. What do you think?
Well, it's really up to Jane. I mean, I think that Tina is getting, I mean, whatever the reason is, they are getting a deal. But Jane, do you want to talk privately, or do you want to talk privately about this? What do you think?
Well, I know that we have to go to court. The judge, that's what our mediator just told me. Is that correct?
Well, we got a call. I got a call specifically from the lawyers who told me the judge had called them. And he basically said, this case is in the trial list. There'll be no more adjournments. And basically said to them, get it done. And they said, well, do you recommend anybody? And the court recommended that I do this. So basically they're telling me, push it, get it done, get this resolved. You guys don't belong in a courtroom. You don't belong arguing and calling witnesses and going into examination. You guys should be together again and resolving this in a way that both of you feel comfortable and moving on with your lives.
Well, if my lawyer thinks that this is something I should consider.
Jack?
Well, I do think that, you know, given everything, it's an offer. Yeah, I think that you should consider it.
Well, I miss you very much for my sister and working with her. That's the best part of it. And with the additional buy-in of $750 from my sister, and then the additional monies for me, which would be $1 million to me and $750 to my sister. Is that correct from the division?
That's
Yes,
my
it is.
Is that
understanding.
correct?
Yes.
And this is going to be put in writing?
Yes, I am right now. I have another computer, little PC, and I'm typing up in the memorandum of understanding as we speak. What I will do is finish it, email it to both of you. You'll review it with your clients, email it back with a note saying this is acceptable. And while it may not be signed because I don't know how to actually do the signature part of the computer system, it will be acknowledged and I believe it will be binding.
Okay,
Thank you, Lucille.
then I'm
Thank-
okay. Thank you.
Great.
Thank you, Jane.
Thank you.
I miss you, and I'm happy that we could do this
Just to
today.
make sure everything is clear, I would go over the terms with you. The original buy-in price is $750,000. Tina will be able to buy into the new property for that amount of money. There'll be equal partners. It'll be in writing. The two women, the twins, will manage the place, period. In terms of the division of the monies that are left, that will be slightly in Jane's favor because of the diminution in value, the lesson in value, and the incredible increase in value of the other hotel. So Jane's going to get $1 million and Tina's going to get $750,000, which, by the way, is a pretty good return on investment. And that will resolve the matter. There'll be no counsel fees. You guys are splitting my fees 50-50. And I will see all you guys hopefully in the future. Please stay well. I'll send you the MOU as soon as we hang
I
up.
hope we don't see you again on this case, that's for sure.
Oh, we're done. Thank you very much.
Thank you.
Okay, thank you.
And that's it. And we are on time.
Thank
You
you.
are right on time. I thought that was really good. Brad, is this how you typically do a mediation?
Yes, I typically try to work with the folks to get a resolution and continually remind them that this is your last chance to resolve it before they go to court. And the court will be more expensive, it'll be antagonistic, it'll be rolling the dice. But with the mediation, they are resolving the matter in a manner which they feel comfortable because they are in fact agreeing to it. They're part of the resolution, they're agreeing to the resolution, and therefore it's much more likely to be enforced, if you will, or accepted.
Okay, so, but you didn't seem to follow the stereotypical pattern of a former judge who was very evaluative, very directive. How come?
Well, there are two reasons. A, we're in a half-hour time period.
You mean you would have done it if you had more time?
I would have done it if we had more time, and I'll tell you why. If we had more time, I would have been initially just listening, and I would have been trying to draw out from people how they felt and what this was all about. But because we only had a half hour, I felt that we needed to really push to resolution. And I don't know if folks know this, but we worked out the resolution in a sense before we started. So that's why I was as aggressive with the resolution as it might have appeared to be. If we had more time, I would have spent an hour with the parties and just talked about all kinds of stuff, just to try and get them to trust me, to like me, to understand me, and to know that I'm sympathetic and empathetic at everything they're feeling and thinking.
Okay. How important was it to the resolution that you divided the personal aspect of it from the business aspect?
Well, I think you needed to speak to the litigants. I thought it was important because of the leverage issue, because I think if you solve one problem at a time, it makes it easier to say, okay, you got to solve this too. And when you have an emotional connection, the way these litigants did, and you can use it, because a lot of times you can't. A lot of times they don't like each other, and it makes a resolution harder. But where I have two folks, two relatives, two sisters saying, I really love my sister, I want to work with my sister, then the question is, how do we use that to bring them together again and have them work together? So I think you need to look at the emotional bonds and leverage it, be it on the good side or bad side.
Can I chime in for a second?
Sure.
Yeah, I mean, I think that is really important. It's like even in matrimonial cases, especially because while the two litigants may really hate each other, I mean, I've seen it where they may have a shared bond, or one or the other has a bond with a witness that might be in the case. And, where someone says, I'm willing to give something up so that so-and-so may not have to testify, for example, for whatever the issue is. So as opposed to having this particular witness testify, be deposed, be cross-examined, things like that a case may settle prior to or during litigation for that reason. So I think that those emotional bonds and that part of it, those personal attachments, I think are very important. And I think that was, that was shown out in this case.
So if the emotional part, the relationship part was so essential to this, and it looked like they wanted it, why didn't you stay in joint session rather than caucusing? Because then you could have really played on that relationship issue.
I think that's a good question. I think either one can work. I, as a personal preference, like to hear how the other person is feeling and thinking without the influence, burden, or presence of the other party, because I think I'll get a more honest answer. I also am always careful, because the slightest slip of the tongue, the slightest can engender a negative reaction.
Yeah.
So if I take them separate, I can listen carefully to the litigant and guide the litigant into a general statement, if you will, that's more positive. And then when I bring them together, I make that statement on the record. I say, you guys really want to work together. You really love each other. We got to resolve this thing. So that even if there were some negative things, I avoid making that part of the record with the two of them there, but point to the bonds they have in an effort to make it a more amicable, reasonable resolution.
Okay, so I'm going to open this up for questions now. So does anyone who wants to ask a question, please raise your hand. Let's see if I have anyone. Okay, Jay. Now, Jay, I'm going to allow you to talk. Go ahead.
Hi. Firstly, I want to tell everybody they did a terrific job, especially Lucille, who was one of my former mentors. And it's nice to see you again. But there are some questions that came up in the course of the session. It seems to me that there were three questions. The first question was with respect to the $750,000 that was taken out by party number two and then reinvested into the second hotel. The value of the first hotel may not have been worth the $1.5 or $3,000 they thought of, because quite frankly, there was no, from what I certainly didn't hear anything, there was no evaluation done to see whether the 750 was a proper number to take out. So it's quite possible that the second party should be refunding some of the money back to the first party. But that would have to be resolved and looked at, or should have been looked at, before they took the money out. Then I said also, while it was going on, it seems that there has not been a partnership agreement between the sisters with respect to Hotel One. And that certainly came out. And this should be addressed going forward, leaving the husbands out, which apparently came about. But also they should have clauses in there taking care of the management in the event that, when one sister is not able to perform, and that goes without saying. But those are the comments I had with respect to this particular case.
The problem was actually developed with the women being the brains of the outfit. On a personal level, I have 3 daughters, so I always make women the
I know. I won't go there. The point is that really the error initially arose in my mind is that the second party was allowed to take the 750 out without any real substantive reasoning, supporting that withdrawal. And if that had been done, perhaps you wouldn't have been here.
The thing is, Jay, that this mediation before you today was supposedly the third one of this particular case.
Yeah.
So a lot of that initial transfer of monies, supposedly would have been done. And this was the only, or the two that Brad had said, the only issues that we call, in the labor word, framing the issue. This is what we're here for, to keep. So you're right, but, this was a continuation of a problem that had been addressed. Yeah.
Well, that's the businessman in me coming out. What can I tell you?
I know that.
Okay, Mark, Annett, go ahead.
Can you hear me?
Yes.
Yes.
My question was around when you were in the private meeting with the one party, and the mediator came back and said, "I think this is a good deal."
Yep.
And it was that interjection of, can that come back to haunt you?
Yep.
Going down a road like that.
That's a great point out to an error I made. I do it more than I should. It comes from being on a bench for 20 years. I try to avoid it, and I try to get it to the point where the litigant says that's a good deal. But you're right, Mark. I should avoid it, but I have to tell you, I probably do it more than most, and I should avoid that. Good point.
I would say, though, that when you were in the separate caucus with Tina and her attorney, you heard the reasoning behind Tina accepting the fact that she would take slightly less than her twin sister because of the increased value of the second hotel. So even though you recognize that you gave your opinion, I think it was based on something that you heard, and I would have supported that.
Yeah.
I mean, to go back, so even just because I think it's just we're under the gun time-wise, and then we're under the, we're trying to shoehorn a lot of things into a half an hour. I mean, so when the proposal was suggested, Jane, will you accept $1.75 million split? And it was posed to Jane, and Jane turned to me as her attorney and said, well, if my counsel thinks it's a good idea. So as the attorney, I wanted to say, well, let's definitely go out in the hallway and talk about this.
Exactly.
I mean, I would have never said, yeah, I think it's a good idea, because what if Jane didn't think it was a good idea? I mean, we would have to just recite all the reasons why she would take a settlement or not. Now, in private, I might say, yeah, I think it's a great idea. You're going to save all this money and what have you. But again, that's just because this is just we're trying to expedite this, go quickly, what have you. But that conversation would have never really happened in front of everybody either. We would have just at least just stepped outside the door or something.
Yep. It would allow
Yeah. No way.
It would have taken a lot longer to resolve stuff. And we did shortcut it considerably.
Right.
Oh, yeah. We even left out that nice little clincher, too. Right.
Okay, we have another question from Glenn.
Hello, Glenn.
Yeah, I think everybody did a fantastic job. I was just surprised that neither of the attorneys picked up on the fact of tax consequences or benefits of the transaction. Is that something that should have been brought up, or is it just because of the period of time that we're discussing?
I think it's probably a little bit of both. You know, clearly the tax consequences are something that would be important depending upon, you know, what they are, because it could be substantial with a $750,000, you know, buy-in and $1 million division. But given the time frame that we had, Glenn, it's tough, you know. But I
was thinking more along the lines that the tax consequences is a selling factor for one of the parties to let them know they're getting a bigger benefit than they might appear on paper.
Good point.
True.
So if you had more time in this role play, would you have spent some more time on why one hotel appeared to go down, what did go down in value, and what the reasons were for that? And the other side, you very clearly talked about maybe the reason the other one went up so much was location. It seemed to be sort of accepted, well, the other one went down because it wasn't managed well.
That was not accepted by me at all. I didn't think I.
No, I know you didn't.
But
Right.
but I think that that's the crux of the whole problem here. That's the whole entire case, is that one hotel, when they anticipated a certain value for the first hotel and it was not that value, and the second hotel they're anticipating this value today, which may or may not be real. So I think that was the crux of the case.
Right, and that's so if the case went on to litigation, right? If it really did go to a trial, that's all expert testimony, right? I mean, these ladies can talk about anything that they want, but eventually there would have had to have been business. There would have had to have been experts. There would either have, I'm sure, forensic accountants to look at the books, and similar, there would have to be real estate formal appraisals. And so maybe that was one of the concerns going into this. Maybe these two sisters didn't want to spend the money that they needed to get ready for trial. That happens. Like, well, an expert's going to cause this, that, the other thing. Maybe they didn't want to spend it, and their lawyers told them all along, if we end up at trial, you're going to need an expert because a lot of this is all opinion testimony.
Right. Couldn't you have, if you had more time and you weren't, you know, right up against the trial gun, couldn't you have brought an expert into this mediation? I mean, we do that in divorce all the time, bring an expert in to look at those kinds of things.
Or you would have reports from the experts. The other problem is an evidentiary one, because he's talking about real estate transactions and nothing's in writing. So you've got some real lawyer issues that would have to be dealt with, none of which we dealt with because that could take a whole morning or afternoon.
Okay, Felicia has a question.
Hello, Felicia.
Felicia.
Yeah, hi everybody. Great job. It was so nice to watch all of you do this and actually be a participant. But yeah, excellent. I do have a question for you, Judge, about the MOU for civil mediations. Customarily, we let the attorneys write up any type of term sheet or settlement agreement. And here you kept saying that you were doing it. And I didn't know if, because you said you were the go-to guy, get this done, if you were empowered by the court, if they told you you needed to do this, or if this is something you customarily do.
I have a standard practice when I had an office that I have a form, and the first paragraph talks about, you know, we're going to be writing this agreement up, what it means. Everybody waives various things. Everybody accepts the resolution as a memorandum. Then there's an open space, and you can make it pages long if you want to. And as we would agree to things, I would handwrite it or if somebody had a better handwriting than I would, they would handwrite it in, so that by the end of the mediation, there would be a rough term sheet. You know, it wouldn't be fancy, but it would at least give some of the specifics, if not all the specifics of the agreement, because no term sheet is really completely done, you know, in terms of an actual agreement. Now with computers, I was thinking, what can I do to make this the same kind of resolution? What can I do to make it binding? What can I do to get quote unquote signatures on it when I know I can't get signatures on it, so that if it's done, it's enforceable? So I bought myself a little PC that I have next to me. And as we do an agreement, I have the first paragraph in, and I'll send it out to you guys. You want to see what it looks like. I have no pride of authorship. After the first paragraph, I just start putting in 1, it is agreed that, you know, there will be a buy-in for $750,000. There'll be equal partners. The women will run the place entirely, and it will be in writing. 2, and then I don't, you know, sign it, but when it's done, I then send copies to each of the parties, ask them to review it with their clients and acknowledge that it's acceptable or change it. And I think if they acknowledge it's acceptable, I think you've got a binding agreement. I don't think the court's going to throw it out, given the modern age and video and COVID. But it's not been ruled on. Don't rely on me, but I think it would be binding.
Well, it's not a question of it being binding. The problem is the dangers that lurk there as mediators writing up an agreement for the parties, where if you word it a certain way where it may seem more favorable to one party than the other, or you omit something that would have been essential to one party, it could come back at you, and we try and remove ourselves from.
It can't come back to me for 2 reasons. My opening paragraph talks about the fact that I'm not making a decision. You can't call me as a witness. All those things that Carl's recommended, I have now put in that opening paragraph. And B, I'm not saying it's a term agreement. They are. Lawyers are signing off on it, not me. Okay. In that opening paragraph, I say I'm making no finding. I'm not going to be called to testify, you know, as to what it means, only that it exists. So, you know, I don't sign off on it. Yeah.
So
I think
as a
one way.
follow-up, go ahead.
I'm sorry. I think one way to avoid the problem that Felicia is raising is to ask the parties exactly what language they would want me as a scribe to put in it. And I'm thinking about small claims court cases where you have to write up an agreement. And to avoid that problem that Felicia is mentioning, I might say, here's what I would say. What do you think? And they'd say, well, say this instead. And so that I just put down what they say.
Jack,
Exactly. There's the difference between the drafter and the scrivener. So
and there were things in that email you disagreed with. Would you change the term sheet and say, Judge, I can't do this, or Brad, I can't do this. This I can accept?
Judge,
I'm sorry. Go ahead, Tina.
Just real quick question. If you had pro se people that you were working with and it was private mediation outside the court system, private mediation with 2 pro ses, would you do the same thing?
Pro se, no, pro ses, I have real problems.
So different, yeah.
I don't want to get involved in it.
I know that.
I have a paragraph saying, more than one, you're told to get a lawyer, you better get a lawyer, and I'm not signing this, and you better get a lawyer to look at it. Because
good one.
Yeah.
The same as if it's an in-person mediation and we're just down to the terms, there's a piece of paper. I have a better handwriting, my penmanship, as they dictate, I am scribing. What I've done with the virtual, I've shared the screen, and you know, I just have a thing. Terms of agreement. I have the case name on top, nothing else. 1, they do, I type. It's their agreement. It goes to them because I email it to them. They sign, they send it to each other, and we all have it. That is how best I've worked with virtual, but it's identical to real life. I stick the paper on the table.
And the thing that's good about it is, and the thing that you avoid is people going home and having buyer's regret.
Yeah, I tell them up front, they do not leave me. If there's an agreement, they do not leave me until they both sign that. Because if they leave,
who knows?
That's it. It's not.
See, I thought
that's a deal. That's a deal.
Okay,
I
have one-
thought, though, by the rules, I didn't think that as mediators, we were even allowed to be the scriveners. So you're saying you think we can be the scrivener as long as we're just, like, literally just being
Oh, sure.
shorthand order.
Yes, there's that distinction. We
Big
absolutely can be the
distinction.
scriveners.
well, there's
We're
no,
not signing it. They are.
Right, these are
They're
their
being the
words.
drafter.
If you have a pretty, look, I have Palmer method for those of you who may remember that.
Did you go to that? Yeah.
Okay,
I did too.
and I know you do too. So
No, I have lousy handwriting. It didn't stick.
Oh,
It didn't stick.
okay, we have one
So-
more question that I want to get in because Fran's had his hand up for a while. Fran, go ahead and. Fran,
He's
unmute
muted.
himself. He's not there. Okay,
He's muted, yeah.
and well, then I'll go to Jerry Scola. Jerry,
Hello, Jerry.
They have to unmute, Carl.
I
Yeah.
did.
Can you hear me?
Yes.
Okay. I have a great job, everybody. I have just one question for the mediator. And I know you had time constraints, so that might be the problem. But you made the suggestion of the $1 million
Time.
and they agreed, they picked it up.
Right.
Would you have done that in a normal mediation, or would you let them make come up with that
I
number?
would let them come up. I would talk about numbers maybe. What do you think? But you're absolutely right that it was total time constraints. And also understand that mediation is supposed to be self-determinative. That is, they're supposed to make the decisions. So in a sense, I shouldn't be saying, how about this, or how about that, or I like that agreement, or that sounds fair. It's an interesting issue, and it was done because of our time constraints. We
Okay,
actually,
But what would be wrong with throwing up an option? Like here's,
Yeah,
here's
here's what
something.
Nothing's wrong with that.
Wait a minute.
Yeah, in other words,
I did it right away. There was no, what do you think? I didn't even wait for an answer.
Well, I understand that time is certain. But if you had, if even saying that, what's wrong with throwing out an option saying, I'm just brainstorming here. How about if it were $1 million, blah, blah, whatever it was, whatever the divide was, you're not making a decision. You're just putting out an option, right?
Mhm.
yeah, and you could also start by asking the parties, if you see that they're not moving at all, would you, can I give you a suggestion? In other words, get their consent, yeah, what do you think? And then just offer, and then see how they respond to it.
One of the things I do when I start this, by the way, just real quickly, is I tell the litigants, listen to your lawyers, not me. I may say things you disagree with. I may say things you agree with. I'll give you an honest opinion if I'm asked, but I'm not your lawyer. I'm a neutral. I have no dog in this fight. Listen to your lawyer. You've got a good lawyer. He or she will tell you what's good and what's bad.
Well, with that, I want to thank everybody. I thought it was really very entertaining, very well played by all of you. And so it was really excellent. I want to remind everybody that a week from tomorrow, the 16th, Tuesday the 16th, is the first of the two-part cultural competency program. And for those of you who are attorneys and need these new special credits, the two-part program will give you 4 credits. So it's really good for attorneys, and it's a great program. And so I hope you will sign up for both of them, but certainly next week's. Let's see, what's after that is we're going to have the following week the mock divorce mediation, and then on the 1st, another one of our CLE webinars. So thank you, everyone who attended, and thanks again to our great players.
Stay safe, everybody.
Thank you.
Bye-bye.
Enjoy.
Bye, everybody.
Take care.
Bye-bye.
Bye.
So long.